Howdy, my name is Carl Dore. Welcome to the Trends and Traps for 2019 in the oil and gas services industry related to how to analyze and review and see exposure in the risk analysis world. That's what we do as attorneys. We're constantly evaluating and working with risk assessments between the credit management world and the general counsel's departments. How do those fit? How do they react? How do they handle their contracts, their reviews, their exposure? It's more than just what is the operational issues on a frac job. I'm stuck on the well and I can't get off safely and the guy's out of money. It's bigger and stranger today than that. But I think you're going to find it interesting. We have segments of virtually all the topics we could come up with that would fit your world and your interest today. Everything from how to use a petroleum engineer to analyze the complexities of the customer operator, to what do you do after a bankruptcy and they're trying to claw back and take your money back from you. I hope you enjoy it. Get ready. Thanks. So, if you would, take it away. Tell us about unsecured creditor committees and why should we consider it?
I will. Typically, when I'm speaking in a room with an audience of this size, it's a Q&A format, and I'm usually just saying I don't recall. But glad to be here today, and thanks to everyone for having us. Okay, so a lot of people, my kids always say, "Hey, Dad, we really don't know how to explain what you do." And so let me, I think most people think I'm a lawyer. So what we do, the firm focuses on a lot more than energy, but in Houston, what we really focus on is working primarily with unsecured creditors, occasionally secured lenders, and oftentimes also working with companies in connection with distress situations. And as Carl mentioned, sometimes I'll come in as a chief restructuring officer or an advisor to a company. But what we found roughly 4 years ago is that a lot of the companies that were good to us, largely the service companies, we sometimes were litigating with people that were also very friendly to us as clients, and really made a strategic decision to focus mostly on advising unsecured creditor committees. So we have a number of cases that you would know, Lynn Energy, C&J Energy Services, Shoreline. I think we've done more unsecured creditor committee advisory in the energy space than any other firm. So that's firm-wide. We do things. We're currently in Puerto Rico working with the Government Development Bank. We worked on the bankruptcy for the city of Detroit, and a number of other cases that we know. But here, we've got a 12-person team here, and we focus almost exclusively on advising unsecured creditors in bankruptcies. Okay, so we'll start out with this. It's we got a lot more than moral bankruptcy to deal with now. Tom. So this is a friend of ours who's a professor of law at UCLA, Lynn Lopucky, put together the Lopucky diagram, which I talk about a lot. I've sold a lot of business with a Lopucky diagram. You walk into a room and here's what you're getting into, and you're hired. But what it shows, I think is a great illustration of how complicated and how many parties can be involved in a Chapter 11 process. I won't go through it, but I think everyone has handouts. But as you can see, there's a lot going on, and there are I have a simplified version of this where I break the process into 4 or 5 parts to explain to clients what are we going to have to do when we go through this. And even the simplified version gets difficult. For people who don't do this often, it can be overwhelming. And especially if you're a trade creditor and you're asked, you're presented with a questionnaire from the U.S. Trustee's office, and you have to make the decision: do I sit on a committee? And where do I go through this process as a committee member? So it can be overwhelming, but what I hope to accomplish by the time we're done here is to convince all of you that if you have a chance to sit on the committee, that you should do it. Tom? Okay, so a little bit about the process of forming a committee. You've got a customer files, and if you're a top 20, 25 creditor and you're named on the petition, you will probably get a questionnaire from the U.S. Trustee's office asking about your claim and soliciting your interest in serving on an unsecured creditors committee. The problem is a lot of people that are eligible to sit on the committee don't realize it. And if you're not listed, but you're aware of it, you can always have your counsel, or even pick up the phone and directly call into the U.S. Trustee's office and say, hey, look, we want to be on the committee. Can you get us a form? We actually have a lot of companies that we work with. I always say that we're cheaper than lawyers. They call us instead of them, but they'll call us and ask, we'll call over to the U.S. Trustee's office and get the form for them. So a lot of times when the cases file, we'll just call over there day 1, day 2, have the U.S. Trustee's office provide us the form, and then we typically have it. People know we'll have it, so they call us, and we can just immediately send it over. But if you have a claim, an unsecured claim at a bankruptcy, you can sit on the committee. And even, what I find here in the Southern District of Texas is even if you have a lien right, you can still sit on a committee. That's not the case everywhere. But here, if you have a lien right, the U.S. Trustee's office will allow you to sit. So don't let that be a factor that would make you reconsider attempting to sit on a committee. Tom, I didn't say that. So the process works. It's fairly simple. The U.S. Trustee's office will send out the forms. If you don't get one, you can call and ask for one. I think they typically give you 7 days to respond to the form. And then it works 1 or 2 different ways. In Texas, at least in the Southern District of Texas, they will have what is called an organization meeting, and the U.S. Trustee will select creditors to serve on the committee, and then that notice will go out, and then they'll meet and they'll organize and hire professionals. In other parts of the country, in Delaware, New York, what will happen there is the whole day, they usually get a ballroom in a big hotel. U.S. Trustee's office shows up along with 100 professionals trying to get hired and 20 creditors, and they will actually interview the creditors at what they'll call so we have, at least what I know of, is an organizational meeting. They have formation meetings. So you might have to get on a plane and actually go to Wilmington, Delaware, or go to New York, or most recently in Rex Energy, it was in Pittsburgh, and I was there. You have to go and you have to be interviewed by the U.S. Trustee's office in person to be put on the committee. And then after they interview whoever shows up, then they'll announce the committee, and then the committee will organize on the spot. But that's typically, I would say, 10 to 15 days after the company files. So you really need to be you don't have a very long window of time. And if it's in one of the jurisdictions where you have to show up in person, you've got to be ready to move pretty quickly. The good news for everyone here is we're finding most oil and gas cases now file in Houston. So it's a very easy process. It's not, you don't have to show up in person. You submit a response to the form. The committee's announced, and then you know if you're on it or not. You don't have to spend the time and expense to fly to Delaware, which is not easy to get to always, and take your lawyer with you and go through all that. The role of the committee, while it seems simple, it sometimes gets complicated, but you're the fiduciary who looks out for the interest of all unsecured creditors in the case. Where it gets complicated is it's not always just trade creditors that are on the committee. A lot of times there's unsecured bondholders. So when you have say you've got $200 million of unsecured debt, they will have an indentured trustee. The indentured trustee might try to sit on the committee, and then there will be individual bondholders who may also try to sit on the committee. And a lot of times what they'll do is they will try to load up the committee so the trades can't control the committee. And this is part of the reason why I encourage trades to try to get on the committees, because oftentimes if you don't, you'll have the hedge funds sitting on the committee with their indentured trustee controlling everything. And I will tell you, they do not care about you. They don't care about their mothers. They don't care about anything. They care about and it's when you look at the work that we do, 70% of the time we are hired by committees that are trade dominated. When you look at, there's some like Lynn Energy where they had unsecured bonds, but I think it was a 7-member committee. They had 3 financial institutions. Unfortunately, they had 4 trades, so the trades were able to control the committee. Same thing in Cobalt. You had, I think, 1 indentured trustee in 2 trades. And I'll get to that in a minute, but as a result of that, the trades were looking out for the interest of all creditors, which were by number trades. And the trades got paid out in full, and the financial institutions got paid less than a cent on the dollar. So again, extremely important to try to get on the committee when you can. Let's go, Tom, can we go to the next slide, please? Thank you. So let me, I've covered some of the benefits, but let me go into that in a little more detail. Oftentimes, the members of the committee have especially the trades, you know the history of the relationship with the debtor. You know that the CFO is a crook, or you know that whatever. You guys usually know what the real issues are. The financial institutions don't. Usually the lawyers don't, especially if they're, if you have financial institutions and they're bringing in the New York law firms to run the committees. They probably never even heard of the company. So a lot of times it's the input from the trades that allows the lawyers and for us to know what it is that we need to investigate. So when you're on the committee, you actually have influence over you direct the professionals to do what they do. And for the reason I mentioned earlier, if you're not on the committee, it's going to be the financial institutions making all the calls. If you are on the committee, maybe it's, hey, we're worried about our preference payments, and can we do something about that? Because really, the creditors as a whole are going to benefit if we can find some way to have our preference exposure waived. In a case where you're going to have a 1 cent on the dollar recovery, at least get the benefit of not having to deal with preferences. And when you're on the committee, the benefit of it is driving the outcome, and then also driving the use of estate resources to get to your desired outcome. You call the shots, and you have visibility. The and I don't want to spend a lot of time on this, but when the case files, there's a number of motions that are typically filed. They're important because the debtor, the company, they cannot spend money. They can't borrow money. They can't do anything without authority. So they go in day one and they get interim authority to use their cash or to borrow money. And typically, as part of that interim authority, they're seeking relief that may not always be in the best interest of unsecured creditors. Maybe they're trying to lock up more liens. A number of different things. So the first day hearing, you're not organized quickly enough to really respond to it. But you do, when those interim orders come up for a final hearing, you need to be organized, and you need to see what's out there. You need direction from counsel and your advisors and people like us who actually go through the documents and summarize them and say, here are your issues. But that's, it's very important to keep an eye on the first day motions and to be talking to counsel and understand. And even if you're not on the committee, by the way, if you're trying to gauge your recovery on a claim that you may have, it's good to be looking at this stuff and have your credit people working with in-house counsel and evaluating exposure on some of these. Tom, can we go to the next slide, please? So I want to talk briefly, say you're how do you get your recovery? Where does the recovery come from? You've got banks and they've got liens, and you hear all these horror stories of getting cents on the dollar. How do you get a recovery? And I'll give you an example of something I was working on just yesterday that I'll talk about generally. There is a company that has filed bankruptcy for the second time. Okay, and there's going to be a lot of those. So when the company came out of bankruptcy for the first time, the judge confirmed a plan, and as part of that plan, he blessed liens to the new lender going forward. Okay. Fast forward a year or two, company files again, and everyone's like, okay, well, what are we going to do? The liens have been blessed. There's no source of recovery. There's $1 billion in debt, and the assets are probably worth $400 or $500 million. We're totally underwater. And people will give up in that scenario. Well, we actually have a different view that we know who the law firms were that were used by the first lien lenders, and they're not from here, and they don't have oil and gas lawyers. We know that the company spent roughly $200 million between the time they came out of bankruptcy and the time they filed a second time. And we know that the PV10 value on the wells that were drilled during that time was roughly $300 million. We know that some of those wells are in Oklahoma, and all the lawyers in here that work with state lien statutes, it's like a eureka moment when you find out that you have liens filed in Oklahoma, because it's almost impossible to get them right. So, we look at this as, okay, here's an opportunity. We've got $300 million of value. We know the law firms that worked on it. We know they're probably not going to be done well. We know they're probably not going to be properly recorded, because these law firms don't know how to do that. There's an opportunity. And, do we actually end up litigating the lien imperfections? Probably not. But does it give us enough leverage in negotiating with the lenders and with the debtor to try to get them to support full payment of a class of trades? Yeah, it's those little, you find the weakness and you leverage it. And these banks don't want to have to litigate lien imperfection. They don't, and especially when the wells are in Oklahoma. It's expensive, and if it's a small trade class, it's less expensive for them to pay you and to have the certainty and move the process along than to drag it out. So That's an example. A lot of times we will really push the debtor to assume all the contracts. I mean, unless there are some really underwater ones, but that's more of an issue for the secured creditors going forward as it is for us. So we really will push that, oftentimes using that leverage to try to negotiate assumption of contracts that otherwise might not be assumed. Preference payments, I'm a big believer, and we just did it recently in a case called Francis Drilling Fluids, which was it's a smaller service company where we ended up on the committee based in Lafayette. The creditors there were worried about their preference exposure. They knew they weren't going to get anything out of the case, but they've been paid a lot of money in that 90 days going into the bankruptcy. So what we negotiated was, okay, well, in a nuance here that I should explain, typically when a bank or a lender gives authority to a company to use their cash or to borrow money and then use the borrowed money to fund their operating expenses, etc., they can't take a lien on what they call avoidance actions, and that's all the money that will come back into the estate when the trustee sues everyone for preferences and fraudulent transfers and all that. But they'll take a lien on the proceeds of fraudulent transfers. So if they litigate after the bankruptcy, a bunch of money comes in, they'll take a lien on that, so it all goes back to the lender anyway. Well, what we did in this case is we got the lender to agree not to take a lien on the proceeds of the preferences. They all went to it is, as Puree said before, this is the double black, top secret, stays in this room. I'll deny ever having said it, even though it's in print. We put the preferences in an underfunded trust, and there will not be enough money for anyone to ever go and pursue those preferences. And those trade creditors will never have to worry about anyone coming after them for the payments that they received in the 90 days leading up to the bankruptcy. So, and then there's D&O claims. It's just a leverage point. Sometimes there's money there, sometimes there's not. But it is one of those things that we will leverage. And as I said before, the importance sometimes of having trade creditors on the committee is you'll know where the potential D&O claims are oftentimes better than anyone else in the case. Because you've been working with the companies and you hear the gossip and you see it. Tom? So let me, this is a case I mentioned before, Cobalt. Are people in here familiar with Cobalt? It was a deep water operator in the Gulf, and then they had some assets in Africa, offshore. When they filed, they had $1.4 billion of unsecured notes. They had probably $10 million a trade, and my prediction was that the assets were probably worth about $500 million. Now, some other firms came in and said, "Oh, they're worth $1.5 billion, $1.6 billion," and we knew that the case was extremely underwater. What we found, though, is the trade was all in an entity that was not a guarantor of the unsecured notes, which may not have been figured out, but eventually we were able to prevent those from being consolidated, and there really wasn't anything that the note holders could do about it. I think of the $1.4 billion, they got $500,000. And then the $10 million a trade all got paid in full. And actually, they just received, this plan got confirmed middle of last year, and about 2 or 3 months ago, they finally got their payment made from the post-confirmation trust. So all that trade paid. Yes, it was $5 million, or $5 million, not 500,000, but yeah, 0.4% recovery for the $1 billion for bonds in that case. Next slide. Okay, another thing that we see a lot is the investment banks come in. And folks, we're not cheap. I'll tell you that right now, and people constantly complain about our fees. But when you look at the investment banks, I'll tell you, and I use Lend just because it's big and the numbers are unbelievable. I think the original proposed investment banking fee for Lazard was going to yield a $60 million fee. It was unbelievable, and we got involved in using data that we keep to track investment banking fees. We're able to show that it was probably $30 or $40 million higher than it should have been, and ultimately negotiated a reduction in their fee that translated into, Logan, what was it, 25 million, $30 million reduction? And that's oftentimes when the unsecured creditors are what we call the fulcrum security, meaning everybody else is paid and every dollar coming in at that point will go to you. $60 million is a lot of money. In Rex, what we did is, this is an example. We charted out all the different investment banking fees as a percentage based on asset value, and the proposed fee for the investment bank there, you can see it's red and it's way up above everything else. We go to them like, hey guys, look, this is unbelievable. I mean, look at how high this is. And using that, we're ultimately able to negotiate their fee back down to something that would be on the trend line. Still very, very high, and still came out of the pocket of the unsecured creditors. But it was significantly less than it would have been. But the bigger the case, the more important it is to be able to have the data to go in and negotiate down the fees. Because if you don't have the data, you have no basis for doing that. So let's go to the next slide, please. Okay, so back on lien perfection issues, we have a process. People think of lawyers being the ones that typically will evaluate lien imperfection issues. We actually do a lot of that in our shop, and we have a process that we go through, and have done it successfully in several cases. I guess we've done it in at least these 5 cases. But I'll tell you, I remember very clearly in mid-states, the first day of the bankruptcy, and I'm in the courtroom, and they come out and they announce that they're 98.8% perfected, the mortgages. No way. Like, no way. If 90 is high, typically, Carl, what would you say, 85, 80, sometimes lower?
Yeah.
To come into court day one, and by the way, this was a New York lawyer who probably didn't even know what it meant or didn't understand why you need room. And I said to the team, this is going to be good. And we started pulling title opinions and mortgages, and a lot of it was in Oklahoma. And we got it from 98.8% down to, I don't remember the ultimate number. I know we stopped at around 90, and we had an argument for going all the way down to 70 something. So, it's extremely important to know how to do this. I think, at least in a large bankruptcy, this is how you get your recovery, is being able to go in and blow up liens, or at least have a viable threat of blowing up liens. And the bigger the case and the higher the likelihood that it's a firm without an office in Houston, the more likely you are to be able to do it. And we use, Carl's on a lot of the committees that I sit on, and we go to him for guidance, especially when it's a multi-state case, because all the different states are different. I just know Oklahoma is good. But it's, we have had in our large conference room, we have had 15 people in there with tens of thousands of pages of title opinions and mortgages, and it's almost a ticketed time exercise. Okay, well, here's what was filed at the courthouse. Here's the title opinion. Here's the mortgage. Page number's wrong. So there, it's in Oklahoma, it has to be perfect. So again, I can't stress enough the importance of this. It is the ultimate leverage point that I see in trying to get recoveries for unsecureds. Tom, you want to go to the next slide, please? Okay. I mentioned before the Chapter 22s that are coming, and I wanted you to get your money's worth out of my 45 minutes. I think did we pass around some of those? We have we're going to share with you some of the companies that we're looking at right now, and they may be on your tables. I'm not sure if they are or not. But these are the ones on our radar. I would encourage you to. We've got some analysis, and it's not Wall Street grade, but it'll give you an idea of what we're looking at, what some of the issues are, and where I think in some of them where the bonds are trading. One thing important too, when you have unsecured bonds in a case and you have a claim, you have equal recovery opportunity as the unsecured bonds. So if at any given time you go out and look and see, okay, these bonds are trading at 40 cents on the dollar, and you have a claim, you can, if the market is suggesting that the bonds are worth 40 cents on the dollar, you can assume that your claim is probably looking at a 40% recovery. Important, when the phone rings and the claim trader calls and says, hey, I want to buy your claim for 5 cents. You go look and you see where the bonds are trading and they're at 40 cents. Do not sell your claim for 5 cents. But anyway, these are some of the cases that we're looking at. Vanguard just filed. I think that most of these others have a strong chance of filing soon. Tom, you want to go to the next slide? But as we have spent the last month, I've got a group, and they've done a great job of going back and looking at all the Chapter 11 bankruptcies that were filed over the last 3 years, at least the big ones. And when a bankruptcy gets confirmed, there has to be feasibility demonstrated in the plan. And so we've gone back and looked at feasibility and the assumptions that were used to determine whether or not a plan was feasible, to figure out what happened. They said they were determined to be feasible 2 years ago. Why are we back in this situation now? I would have sworn that it was pricing. Everyone assumed $70, $75 oil, and it ended up being 55. I think forward prices are still 55. That's not it. That's absolutely not it. To the detriment of everyone in here, at least with the service company, what actually happened was the CapEx numbers were a fraction of what they were supposed to be. They didn't drill what they said they would drill. You can see here, the commodity pricing, the first one, it's right about where it was supposed to be. CapEx, way lower than it was supposed to be, which is driving lower production. The problem with CapEx, and this is for the salespeople, not the credit people, that's billions of dollars that were projected to be spent on service companies that were never spent. Worst case scenario, most of these plans, 75% lower than what they were anticipating spending. So that's it's not pricing, it is lack of CapEx spend by a lot of the companies that came out of the gate 2 years ago that's going to drive them back into a distressed situation. Tom? Here's some more similar data, but by company that we looked at. You look at Ultra, you look at Halcon. massive production impact by unfavorable CapEx spend. Okay, go ahead, Tom. So, here we are. It's usually things are usually beyond hope by the time that the problem's identified and the people try to fix the situation. But for you, have things on your radar. Have these, and feel free to call us if you have a question about at least a mid-sized company or greater, because we're looking at all of them. The other thing I would encourage you to do that we've started doing a few years ago is look to see, and everyone in here is probably better about it than we are, but we are very careful about looking at who's filing liens. There's a certain individual that we all know who's not here right now who loves to file liens, and as soon as we see him file liens, we start looking to see who else is going to file a lien. And the lien filings are actually almost as good of an indicator as the bond trading prices on where you're going to have a problem. Once I start seeing certain people filing liens, it puts those companies on my radar. And if I'm managing credit, I'm starting to get a lot more careful. I'm probably considering filing liens myself, but I'm starting to think about potential preference issues. I'm looking at bond prices. If I see liens and I see bonds trading at 20 cents on the dollar, I'm going to be very, very, very cautious extending credit to that company. So I think I've got a couple minutes, so I'll open for questions. Ed.
So one thing you didn't talk about, which I think would be good for the...
Just one?
For you to just one. So at the beginning of every one of these cases, I think every credit manager in this room calls up the company in bankruptcy and says, I want to be a critical vendor. And so talk about how that impacts the committee, and the critical vendors.
Great point. And actually, thank you for bringing it up because it is something I wanted to touch on because I think it scares a lot of people off of committees. There is a process by which if you're determined critical by the company, they will get authority to pay you. This is probably not where you're going with it, but I'm going to take us somewhere. A lot of people see a critical vendor motion and think, oh, well, I'm going to get paid. Everything's going to be great. They may or may not get a phone call saying that they're going to get paid. You're not paid until you're paid. And a lot of times commitments are made by debtors that are really outside of their control. And a lot of times being a critical vendor means that they're going to come to you and they may pay you, but they may only want to pay you. They may say, hey, we'll pay you as a critical vendor, but we only have a pot of money this size and we can only pay you 60 cents on the dollar as a critical vendor. My point is, if you're considering being on a committee, and I encourage everyone in here to do it when it makes, as often, if you think it might make sense, just do it. You can always drop off. It doesn't really cost anything. There's not a lot of risk involved. But even if they commit to you that you're going to get critical vendor treatment, you're going to get paid, get on the committee until you get paid. Even if they tell you you're a critical vendor, do not believe it until the check's not in the mail, but actually in your hands. And a lot of times people do get paid, and they'll get paid in full as critical vendors. And a lot of debtors they will try to avoid having a committee by convincing people that they're going to get paid and not sit on a committee. But don't believe for a moment that all because there's a critical vendor motion that you're going to get paid. And what I see these days is it's a pot of money. Say there's 50 million of claims that may be critical. They might get a $30 million pot, and they're going to come try to pay you 60 cents on the dollar to negotiate ongoing trade credit. How to do it?
Well, fine.
I would. Would you talk about the use of the lien as a manipulated tactic to get paid and then release it again as an avoidance of a potential preference claim.
The use of a lien,
Yeah, you mentioned it to me. I'd never heard of this being done. Using the lien to say, I'm going to file a lien, you pay me, then I'll release it, then it's not a preference.
yeah, well,
Instead of a COD.
I would love to take credit for that. I guess that would work. I've not done that.
I've never done it either. I was assuming that you did.
No, I mean, we've done a lot of fairly exotic things, and we've done a lot of them with your help. But yeah, there's a lot that you can do, and there are a lot of great lawyers, especially in this room, that can help. I mean, you really do have to get creative and engineer some of this stuff sometimes, and especially. And one that I got a lot of help from Carl on was where I had a pressure pumping company that I was an officer of, and we had subs, and then the operators were filing liens on the subs and wouldn't pay us until they got paid. No, I'm sorry, I got that back. The subs were filing liens on the operators, and the operators wouldn't pay us because of the liens, and we couldn't pay the subs. Even though I called it equity and receivables, because if we owed them 60 cents, the operators were putting liens on them that might be where we may have receivables. We may have a receivable of $1, but we owed them 60 cents, and we couldn't get any of it until we paid them the rest of the 40 cents. So we could pay 40 cents to get $1. But until we could break that up, it gets complicated. We were just in gridlock. And Carl, you may remember that was that Fort Worth. We had, I think, 11.
Yeah, the call was, there's like $25 million of receivables. What do we do?
It totally locked up. It wasn't just 25 million of receivables. It was 25 million of equity in the receivables that if we could just make some payments to the subs to release the liens on the operators would flow back down to the company that we were working with. So the lien stuff gets complicated, and I'm just an accountant that talks about liens. But anyway, anything else? Okay, well, thank you very much for the opportunity.